Hello everyone. Welcome to CM Murray's edition of ReguLaw, our regulatory podcast. My name's Liz Pearson. I'm an associate in the team, and today I'm joined by Andrew Pavlovic, one of our partners, and Michael Evans from Byfield. We're going to be discussing the reputational consequences of SRA investigations and potential SDT prosecutions, and how individuals and firms can attempt to manage that. Anyone working in this area will know that reputational factors are often a key element of the decision-making process. And with the SRA's increased focus on non-financial regulatory matters, such as sexual harassment or other forms of, so we say, the more salacious misconduct, there are reputational damages that can be associated with the publication of any of these adverse findings. And that can have, in fact, greater consequences than the prosecutorial outcome itself. So the format of today's podcast, we'll take it chronologically. We'll look at the various points at which SRA proceedings can enter the public domain and consider what individuals and firms need to think about from a reputational perspective at each stage of the process. So Andrew, if I can turn to you at the investigative stage, what's the SRA's position regarding publication of an ongoing investigation?
Yeah, so SRA investigations are confidential, so they shouldn't enter the public domain. The exception to this is in relation to high-profile matters of public interest, such as the post office scandal or the accident investigation, where the SRA will issue periodic and fairly generic updates as to the progress of investigations. So just by way of example, the SRA issued an update on its investigation into the post office in February this year, just saying they have over 20 live investigations and they're hoping to commence prosecutions in the tribunal in the summer. So you might get something like that in the more high-profile matters, but generally you won't see SRA investigations being put into the public domain. There's two sort of quick things I would note there. The SRA will usually inform an individual's employer when they commence an investigation into their conduct. So if an individual is being investigated for something that happened at a former firm, the SRA will inform their current employer. So that's sort of one sort of slight exception. And the second one is that the SRA may need to go outside of the individual's current firm to investigate a matter. So an example would be where a witness to alleged misconduct or even a complainant is no longer at the same firm as an individual being investigated. So in general, the wider the scope of the investigation, so the greater the likelihood that things might find their way into the public domain. And this is probably more of Michael's area, but you do occasionally see reports, for example, enrolled on Friday in relation to ongoing investigations. That could be either an internal or a regulatory investigation, although usually these won't name the individual being investigated. So yes, generally confidential, but still a couple of ways in which you could see that they could find themselves into the public domain.
Thanks, Andrew. And Michael, then, even if it's not in the public domain, are there things that people should be thinking about firms and individuals from a PR perspective at that early stage?
Thanks, Liz. Absolutely. I think particularly when we're talking about the types of non-financial misconduct that you referred to, where there might be a more salacious element to it, but also it's something which goes to the heart of the kind of commitments that firms make to, look after their people. Fundamentally, it's where does an SRA investigation come from in these cases? It's not happening because the SRA is actively monitoring firms. It's coming because the firm has self-reported something. If a firm has self-reported something that's significant, the firm is probably also investigating it itself. So the issues around publicity and the issues around confidentiality, as much as anything, come from that lens rather than the SRA process at this early stage. Can a firm keep a process sufficiently confidential? Can an investigation, there may be suspensions of people, there may be things going on. It really depends on the culture of a firm, the size and the scale of a firm. But the bigger the firm, generally speaking, the more likely it is that, it's going to be noted internally. And so it's about stakeholder management. The reputational risk starts early. right? And the reputational risk is not just if something is published and roll on Friday. That could happen at some point a long way down the line, or if you're unlucky, it could happen relatively early in the process. But there are always there's the individuals impacted or concerned, the sort of antagonists, protagonists, and whatever it is that may have happened. There are the people around them, the clients, all of that needs to be taken into consideration. So the stakeholder communications planning and the leak planning really needs to start before the investigation starts by a firm, really. What the SRA does further down the line is at this stage secondary, because as Andrew says, it's pretty unlikely that it's going to be publicized by the SRA except in particular circumstances. But holding something within a firm for a prolonged period of time is really hard.
That's really interesting, Michael, as well, when you're considering, the variations on stakeholder rather than just that narrow question of external publication. Okay, well, if we keep progressing through, then we've got the conclusion of the investigation. Andrew, what happens then once the investigation is concluded? What are the potential outcomes? How could those come into the public domain?
Yeah, so there's three outcomes. Firstly is the investigation is closed with the SRA taking no further action. And as the investigation itself is confidential, then obviously that will usually be the end of the matter, and there won't be any publicity in relation to that. Although interestingly, we have seen a recent example of the SRA setting out their reasoning, closing an investigation into a firm who were accused of conducting proceedings which were a SLAP, a strategic lawsuit against public participation. Again, I think that's in response to the sort of the high-profile nature of those sorts of proceedings at the moment. One potential risk here, and this also applies to internal investigations as well, is that the complainant will usually be informed that the SRA investigation has been closed. And so you do have the possibility that someone who's disgruntled with the outcome might go to the press. I mean, Michael, I'm not sure if you've got any experience of that, either from an internal or an SRA perspective.
It can happen. I think you see threats more than reality of it happening. Generally speaking, it's because somebody said something to somebody else who said something to somebody else, and then suddenly you've got something which is true out in the public domain, and then it's very, you cannot comment, but there's only a point. It becomes untenable at a certain point. But I wouldn't say that it's disgruntled parties taking it to the press directly very frequently, but yes, it does happen from time to time. But it's not always the people you think it is.
Yeah, that's a good point. And then you've got the sort of the second stage, which is the settlement. So this would be where the SRA and the individual or the firm agree an outcome. If it's something that the sanction is one that the SRA can give within its own powers, then it will be published on the SRA's website and it will be an SRA decision. If it's a sanction that is more than the SRA can do internally, then it will be what's called an agreed outcome, which needs to be presented to the tribunal for approval. So both of those things will end up being published. And then the final option is a referral to the tribunal, and this would happen where allegations are disputed or the SRA consider that their own internal sanctions are insufficient to deal with the conduct, so it goes beyond a fine, for example. And this is published on the SRA's website after the tribunal has confirmed there is a case to answer. So what happens is the SRA submit the case, the tribunal conduct an initial review to say, is there a case to answer? One point to note here is that it can often be months between the referral being made and the outcome being published on the SRA's website, and there doesn't seem to be any rhyme or reason to it that I've been able to work out. And I've seen some examples where the referral is only published a few weeks before the hearing, and then other examples where it seems to be published months before. So I'm not really sure what drives that, and I guess that's something that can be quite difficult to manage from a PR perspective. And one thing the key thing I'm thinking about at this part of the process and earlier is the potential impact of publication on mental health, particularly when you're acting for individuals who may be accused of doing something very serious. The SRA is a public authority for the purposes of the Human Rights Act, so it has to comply with the European Convention on Human Rights. Article 8, the right of an individual to a private family life. is potentially triggered by publication if you can show that that could cause or trigger health issues, a deterioration in someone's mental health, for example. And in extreme cases where there's a risk that publication could trigger an extremely serious health condition, in Article 2, the right to life could be engaged. So I've acted in cases in the past where an individual's name has been anonymized at the publication stage, so like Solicitor A, for example. And I've also acted in cases where a regulatory settlement agreement has been agreed and it's been published, but it's a very sort of brief summary which removes details of the conduct, as we were able to show that including that level of detail in a published decision would be triggering for the respondent. So it's quite common for mental health issues to arise in investigations, firstly because they're very stressful, they take a long time, but we often see that it's the actual publication of the investigation or the outcome which is most likely to have a triggering effect on an individual. So that's something that we always have to be alive to when we're thinking about the publication stage. And obviously you would have lined up any sort of medical evidence you need earlier than that, but this is really the point where this really comes into focus.
Michael, do those concerns come into it from a PR perspective? Are you swayed by mental health considerations? Are you impacted by that unpredictability of the tribunal timings?
Well, I think one of the things when particularly when we are working with a firm, I mean, we do work with individuals at times, but when working with a firm, particularly, well, throughout, but from an early stage and throughout, we always try and remind everybody that you don't know what an outcome is going to be, and you have to take everybody into account here. And if somebody is facing something which could potentially be career-ending, depending on outcomes, this is going to be absolutely devastating for them. And you need to make sure that they are appropriately supported throughout. And that goes right from the beginning of any kind of internal process all the way through to any subsequent regulatory process and findings. And so it's extremely important to have to bear that in mind throughout. I think we can talk about this a bit later, I think, but some of the new automatic disclosure rules at the SDT and some for Rule 12 documents and responses being published, where there aren't a lot of redactions, it's putting a huge amount more detail around what's alleged to have happened into the public domain, which I think makes it even more salacious and reportable. And I think that's something which will have to be even more carefully considered going forward because of those new rules. But if we rewind just to the point of publication, I think what Andrew was saying about it, that particularly with whether it's something which the SRA is able to handle itself and it's just a decision, a sanction being published, or whether it's a referral to the SDT, that is, particularly for an SDT referral, that is the initial big point of publicity, particularly for a matter that hasn't been in the public domain before. And we have certainly found ourselves having to very closely monitor using software tools in real time the SRA's recent decisions page for changes for a prolonged period of time in high profile referrals where we know it's coming, we just don't know when. And that period of uncertainty can last for weeks or even months. And if a firm in particular is going to get on the front foot with handling a referral properly, it is a prerequisite to know at least at the same time as the journalists what's being published, because they don't need to wait for a firm. This is public regulatory information. They don't need to wait for they don't need to give a right of reply. They can write their story immediately, whether or not they've got a statement from a firm or not. So controlling the narrative, getting key messages out there about what happened, why, how the firm's handling it is absolutely vital. And that requires being on the front foot and being able to manage the media proactively, not on the back foot waiting. So if you can't know exactly, you better be working with the right tools and the right people to be able to at least be running on the same timescale as the media.
Lots of moving parts, Michael. Yeah, for sure. So if we do then get to the tribunal hearing, say we've gone beyond the fine powers or we're in the contested space, um, as you say, Michael, that might be the first point where it's really coming to the fore. And we've touched briefly on the new automatic disclosure policy, and how much that might change the scenario. Andrew, can you give us some grounding in what that policy actually entails, and from the practitioner's perspective first?
Yeah. So this was a new policy introduced in January. So prior to this coming in, a non-party, for example, the national press or the legal press, had to make an application to the tribunal for documents on the case file. And this might be dealt with at the outset of the substantive hearing, which would then eat into the actual time allocated to the substance of the hearing. So the tribunal has changed their procedures, and now on the first day of the substantive hearing, a number of documents will be published on their website. So this includes the Rule 12 statement, which is sort of the equivalent to a particulars of claim in a civil case, setting out the factual and legal basis of the claim, and the respondent's answer, so the answer to those allegations. And the effect of this is that there's now a substantial amount of detail in relation to these cases automatically in the public domain. And we've seen that reflected in some press reports of recent cases that have come before the tribunal. The level of detail in those press reports is a direct result of the fact that they have access automatically to these documents. So from a practitioner's perspective, I would need to consider this from the perspective of what am I happy to put in the public domain, and whether I want to either object to the automatic disclosure policy or put forward a redacted or revised summary of the document which your client would be happy to be disclosed. And again, you would have to put forward some kind of justification as to why it should be redacted or revised. But a common example would be if the documents contained reference to sensitive matters such as medical evidence, if you were putting forward a medical condition as either a sort of partial justification for the conduct or in mitigation. So thinking about that, as you get up to the hearing, or again at an earlier stage, or what would we be comfortable with having automatically published at that point in time. And then if I'm acting for a third party, for example, the firm, then I guess it's just being aware that there could be things mentioned in those documents that you don't have the opportunity to comment on because you're not a party to the proceedings. So a common example would be an allegation made against an individual of dishonesty, where someone has done something dishonest to cover up a mistake, and when that individual gets to the tribunal, they might allege that they were working in an environment where they would not have been supported if they'd admitted to making a mistake. So, the sort of toxic culture defence. The firm's not a party to the proceedings, obviously, so they're not in a position to respond to that. But we could see details laid out in these documents, in this case, the respondent's answer, which could make criticism of firm culture and even individuals. So again, not much you can really do about that from a practitioner's perspective, but certainly something that you need to be aware of. And then it probably goes over to Michael in terms of how you deal with that. But I think it is going to make a significant change, both to the reporting, but also the approach that individuals and firms take to what they put in the pleadings, and the approach they take to the automatic policy when they get to the stage of a hearing.
So it sounds like Michael might be getting a bit busier. Has that happened yet, Michael, or is that anticipated for the near future?
I think it's an inevitability that more PR planning will be required, because of the automatic disclosure rules putting so much more detail into the public domain. So I think it's an interesting one, though, because we talked about uncertainty earlier and how difficult uncertainty is to manage around the SRA publication of a referral notice. One thing that certainly for parties, the automatic disclosure will provide you will at least know what's being published. And you can manage that a little bit more effectively sometimes when you're going through a hearing, particularly a large matter, one that's very interesting to the press, to the profession. Hearings can take unexpected turns. There's some uncertainty about how things come out, etc. there will be more certainty because of largely the media will go off the documents, at least initially. And so you'll be able to predict what's going to be written. It might not be helpful. It might not be easy to deal with. But when you know what they're going to write and you know how they're going to write it, you can manage people's expectations. You can do that stakeholder management more effectively. And that stakeholder management is so important. So I think initially it's going to make things harder, but in the long run, it's not necessarily going to make everything easier, but it will make things a little bit more predictable. So I don't see it as a bad thing, but taking into consideration the impact of the facts coming, or the alleged facts coming into the public domain in detail at this stage will require a lot of preparation. And when we think about the different parties, as Andrew referred to, it is challenging if you are a firm but you're not party to it, seeing things like your culture being brought into it and allegations around a party culture or a toxic culture or an unsupportive culture, and you won't necessarily know what's coming there or be able to really defend yourself as such. And I think that's something which is going to be a difficult thing to manage. Conversely, if a firm is party to proceedings or subject to proceedings, then I don't know, an interesting one. I mean, I'd actually put the question back to Andrew. Do you think that you will see firms writing their answers with the PR in mind a little bit?
Well, I mean, it's an interesting one because obviously you get to see all these documents before the outcome, which is something that different. Yes, you would have press reporting of the hearing as it went along before, but usually the reporting on the detail would come at the end once the tribunal published its written reasons. So here you could be thinking forward. You could be thinking ahead of yourself. Is it going to look really bad, for example, if we deny something and it all gets published before the outcome, and they're saying, how can they possibly be denying this allegation? It's not credible. I think you would so you might have that sort of thought in mind. What is going to play best to the public? What's going to look good to the legal press? I think in general that those things are probably going to be aligned anyway. I think it would be relatively unusual if someone was changing their position purely on this basis that someone might have sort of earlier access to the answer than they might otherwise have done. But you might see an example. You could envisage circumstances by thinking, well, how will this play to the wider legal press when this gets published before the outcome, before the hearings even started? But I don't think in practice it will have much of a difference in terms of how they're drafted, because I'd imagine that most of the time the position that you want to take is going to be consistent. It's going to be a consistent position that you can justify in any event. But certainly, I think it will be something that firms will be thinking about. How would this play out? How would this be seen? And because you get this sort of almost front loading of the reporting as well, so the actual written reasons that come at the end could even get lost a little bit. And I guess that might be your part of the PR response at the end might be to say, well, all of this stuff was published, but if you look what actually happened when the findings were published 7 weeks later, this was what the tribunal actually found. Because I think one of the risks of this is that, as you say, all of this information gets published on the first day of the hearing. It gets thrown into the public domain. It gets reported on. And then will sort of people almost forget at the end of the process when the tribunal publishes its written reasons what the actual findings were, and sort of will your job or the firm's job or the individual job to be to sort of try and pull it back from all of the reporting that we'd seen up to that point. So I think that's going to be quite an interesting thing to watch as well.
Michael, do you have experience in that sort of final stage, months or weeks later, trying to reclaim the narrative and put the conclusions out there?
Generally speaking, it's quite unusual for things to lurch in a completely different direction that far into things. I think something has gone badly wrong if you're having to deal with that right at the end. So of course it can happen where you get something unexpected, but generally speaking, a big case with good advisors and a well-run process should have a reasonable degree of predictability to it in terms of things, and also the tribunal should also be offering a degree of not predictability as such, but it should be relatively obvious what they're focusing on. So something it does happen, but it only generally happens if something has gone wrong.
So the takeaway I'm hearing is good advisors and a well-run process can make even STT rule changes predictable and reasonable.
Yeah.
Well, we have reached the chronological conclusion then of the outcome publication. Unless anyone had any final thoughts, I'm happy to wrap it up there. Andrew, Michael?
And for me, I think it's going to be interesting how this policy works in practice and the changes we could see.
I look forward to a busy 2025 then.
Indeed.
Well, thanks for your time, Michael. Thanks for your time, Andrew. And I'll catch you at the next ReguLaw podcast. Thanks both.
Thanks for having me on. Bye-bye.